right, so now this is the review for Test 2. This is a very complete review, so please pay attention. The coverage for Test 2 includes chapters 6 through 11 and also a couple of questions on recording statutes and title searches. So let's go ahead and get started. All right, so you learned a little bit about judgment liens, and a judgment lien remains against property even if that property is sold. A judgment lien creditor, after a piece of property has been sold, has 10 years to enforce the judgment. You need to know that for the test. Also, you'll need to remember that a judgment lien lasts for 20 years, and it may be extended for an additional 20 years. A lis pendens is a tool that a creditor may use as well. So a lis pendens simply means a notice of an impending lawsuit. Example, Al's a cabinet maker, and he recently filed a suit against a homeowner for non-payment. The cabinet maker now learns that the homeowner has now listed the property for sale. Is there anything that he can do? And the answer is yes, file a lis pendens or a notice of an impending lawsuit. All right, so we talked a little bit about priority of liens as well. And you need to remember this, that a property tax lien is given very top priority. Mechanics liens and materialmen's liens also are given very high priority, and they may actually be superior to the title of the purchaser as well as the deed of trust, so the lender's lien on the property. So mechanics lien, you'll need to know this too, is provided to the extent that value, and in Virginia that's $50 or more, has been added to property by someone who provides either materials or labor. You may have a mechanics, sometimes it's referred to as a materialmen's lien. My note to you is this, that a mechanics lien is not available to real estate brokers. You'll need to know that for the test as well. And finally on this slide, this is 2 more points if you know this. A suit to enforce a recorded mechanics lien must be filed within 6 months of recording the memorandum of lien. Describing land interests. So if you have an inadequate description in a deed, then the deed is not effective. Primarily because you have to be able to determine what piece of property is being conveyed. You'll need to remember this, that the least desirable method of describing a parcel of land in a deed is the street address. And the reason is that street addresses oftentimes change. Meets and bounds was one of the ways that you can describe an interest in property in a deed. Meets simply means distance, bounds means direction. There is an example in your book if you want to go back and look at it on page 126. Be sure if I give you a meets and bounds description that you sketch it out to ensure that the boundaries actually close. Sometimes you'll see a meets and bounds description that is not adequate because the figure does not close. We talked a lot about joint tenancies, and a joint tenancy in Virginia is created intentionally by act of the parties. A joint tenancy has a right of survivorship. Another type of tenancy that has a right of survivorship is a tenancy by the entirety, and these are created by specific language in a deed. All right, so here's a question for you. Al and Bob own a building, and they own it as joint tenants. Al gives his interest to Claire, and Claire dies. Who owns the building? Well, Claire's heirs own half of it, right? So as soon as Al conveyed his interest in the piece of property to Claire, the joint tenancy was dissolved, and then Claire is now a tenant in common with Bob. So in this example, Bob owns half and the heirs of Claire own half. All right, tenancy by the entirety is a type of a joint tenancy that's only created if you have a husband and a wife. Again, it has a right of survivorship, and a divorce would dissolve a tenancy by the entirety, and you have to know that for the test. One of the advantages of a tenancy by the entirety is that only a joint creditor of both the husband and the wife can place a lien on property held as tenants by the entirety. All right, so question for you and a question that's on the test. Can you create a tenancy by the entirety before marriage? And the answer is no. A tenancy in common or tenants in common does not have a right of survivorship. It is a type of joint tenancy without survivorship. If a joint tenant conveys his interest in property, so if you have a joint tenancy and he conveys his interest in property to a third party, the third party would be considered to be a tenant in common. If you need to terminate co-ownership in property, what you file is something known as a partition suit, and you'll need to know that for the test as well. Transfer of title by deed. The interesting thing about deeds and transferring title is that recording is not necessary to transfer title between the grantor, that's the seller, and the grantee. All you have to have is delivery with the intent to transfer title. Almost always, however, deeds are recorded, and they're recorded immediately. And the reason they're recorded immediately is that you want to avoid the possibility of a fraudulent conveyance. In other words, you want to avoid the possibility that the seller sells the same piece of property to more than one grantee. Recording statutes. We only went over this briefly in class, and you will have a question on the test, but it's fairly straightforward. You're going to need to know simply how to apply the recording statutes. And so here's the example. On day one, Oliver conveys property to Al. Al is considered to be a bona fide purchaser in this example. And so I will tell you whether a purchaser is a bona fide purchaser. Bona fide purchaser is simply someone who buys the property without notice of any defense on the property. So Oliver conveys the property to Al, a bona fide purchaser. Oliver then, on day two, conveys the same piece of property to Bob, and Bob also is a bona fide purchaser. He does not know about Al. On day three, Al records his deed. On day four, Bob records his deed. So then the question is, who owns the property? Well, if you're in North Carolina, the answer is fairly straightforward. They have a race statute for deed recordings. In other words, the first person, it's a race to the courthouse, the first person to record wins. And so since in my example I have Al recording first, Al wins. In South Carolina, we follow a race notice statute. And if you're in a race notice jurisdiction, the first good faith purchaser to record wins. In this case, I gave you that Al is a bona fide purchaser, and he was the first good faith purchaser to record. So in that state, so in South Carolina, Al would win. Virginia, our statute is a notice statute, and so the last good faith purchaser wins. And last good faith purchaser in this example is Bob, and so in this case, Bob wins. All right, title examination. The settlement agent for the buyer or an attorney is going to perform a title search. And when a title search is performed, you look to see whether there's marketable title at the time of closing. Oftentimes when you do title searches, you will find that there's some sort of a flaw in the chain of title. Usually these flaws can be fixed. In Virginia, a full title search goes back 60 years, and you have to know that. So actually, you have to know that marketable title is at the time of closing and that a full title search goes back 60 years. In a case where title has to be cleared by having a correction in a deed signed, the seller is the one who's responsible for locating the parties who must sign, and you'll need to know that too. In Virginia, title agents are required by law to tell clients that title insurance is available, and it protects you as a purchaser against many unexpected flaws in property. We talked a little bit about the Virginia Residential Landlord and Tenant Act, and we said that if an application fee to rent a piece of property exceeds $32, then it has to be refunded if the applicant is rejected or if the applicant decides not to rent the premises. And also, we learned that a lease may be oral or it may be written. In Virginia, an oral lease may not last for more than 5 years. Talked a little bit about security deposits, and a security deposit may not exceed 2 months' rent. And if it's held for 13 or more months, then it accrues interest. The landlord has to return any unexpended part of the security deposit along with a written itemization of all damages and deductions. And within 72 hours of a tenancy being terminated, the landlord must inspect the premises, and the tenant has the right to be present during the inspection. Failure to comply with this results in the tenant recovering all of the security deposit. There's several questions on the test from this slide, so go back and take a look at it. Tenants' rights. In terms of a residential lease, yes, indeed, you've learned that there's an implied warranty of habitability. And the implied warranty of habitability warrants that the premises are fit for human habitation. They're fit for uses reasonably intended by the parties. If the landlord fails to provide essential services, then the tenant can recover damages based on a decrease in value of the fair rental. In Virginia, you have the option to pay rent into escrow, and you'll need to remember this, to the general district court if the landlord fails to make repairs. And then, of course, we did talk briefly about the doctrine of emblements, so that a tenant who has planted crops on leased land has the right to harvest them, even after the lease has ended. Tenants' duties. Tenants' duties are to pay rent, pay utilities, keep the premises clean, remove garbage, and repair damage that the tenant has caused. And you'll need to know that. You'll be able to you must be able to identify what are the tenant's duties. A tenant should avoid committing waste. And remember, there are 2 types of waste: ameliorative waste or permissive waste. Ameliorative waste is the example we talked about in class, where a group of students in Farmville decided that they were going to build a brick bar, brick and mortar, a bar in the living room of their rented house. They thought it was beautiful. They thought it enhanced the value of the property. They have now created waste, ameliorative waste, and the landlord can require that this be removed at their expense. In terms of access to rented property, a tenant may not unreasonably deny access to the landlord. And likewise, the landlord is required to give the tenant reasonable notice. Generally, that's deemed to be 24 hours before they come into the property. Remedy for abuse of access includes a termination of the rental agreement or injunctive relief. Commercial leases. Very few states have adopted the Uniform Commercial Landlord and Tenant Act. And I will ask you a question about that, but very few have. So a majority of states have not adopted this law. There's no warranty of habitability, you have to know that too, associated with the commercial lease. Rent for commercial premises oftentimes are calculated based on a percentage of the gross receipts. You'll need to remember that too. And as a rule, a commercial tenant is responsible for finishing interior space, and trade fixtures generally are removable by a tenant. All those things you'll need to know. There are 4 or 5 questions just from the slide. All right, and so then one of the last topics we covered was condominiums, cooperatives, and timeshares. Be able to identify which form of ownership I have described. So if it's a cooperative, a corporation holds title to the property. So you know you have a cooperative if you have a share of stock associated with the ownership. With a condominium, and the owner purchases a living unit in the building. And then with a timeshare, you have multiple purchasers who buy an interest in real property, and the owner's use is limited to a contractual period of time. Cooperative, remember the corporation holds title to property. Prospective tenants buy a share of stock. So cooperative ownership is not classified as ownership of real property. Residents make monthly payments to the corporation to repay the loan and also for maintenance. If one tenant fails to make a monthly payment, the others may be liable. Because of that potential liability, the condominium was later born. A cooperative may also have restrictions on the transfer of shares. Condominium is a form of ownership that evolved due to the liability issues associated with cooperatives. The owner actually purchases a living unit, and residents pay monthly fees to cover maintenance and costs associated with common areas. Failure to pay may result in the condominium association placing a lien on the unit. You need to remember that. Condominium ownership is fee simple. It may be held as tenants in common, joint tenants, or tenants by the entirety. And then once a condominium has been created, 80% of the voting interest is required to terminate it. And you're going to need to know that percentage also. An owner generally has an unrestricted right to sell his or her unit. That's it for our review. Please carefully look at each one of these slides, and best of luck on test 2. Thanks.